Criminal defense attorneys love to tell people, don't give statements. What's that mean? It means if a police officer is investigating you, pulled you over for a traffic citation, calls you, whatever, don't tell them anything. We also like to say if you've ever been arrested, don't give a statement. It becomes even more clear, don't give a statement, because when you're arrested, a police officer says you have the right to remain silent, you have a right to a lawyer, and you have a right to know that anything you say can and will be used against you in a court of law. Those same rights apply if you're under investigation or anytime you're talking to a police officer in their professional role, because they are looking for evidence and facts to support a criminal or crime. And if they're talking to you, they're interested in what you have to say. And the problem with giving a statement at any stage, certainly before you've spoken to somebody who has a lot of experience with criminal investigations and cases and burdens of proof, is you will be stuck with that statement at a future point in time, regardless of whether you didn't remember some facts you should have said. When you look at a police report and it reminds you of something that you should have talked about, whether what you said was subject to bias by the person that listened and didn't write down everything you said, whether there were other witnesses or other facts you didn't know about that subsequently make you want to change your story. And of course, you can also be admitting to a crime when you give a statement. And so, as a criminal defense attorney, private counsel, I deal a lot with the outlier cases. Cases where there's questions about bias, questions about whether what was written down was accurate. And the problem when a client has given a statement is that they don't realize that they have, in essence, chipped into stone what their story is by giving a police officer a statement. Because where do you hear that statement again, or where do those facts get recited again? They get recited in front of a judge or jury. And when you try to tell a judge or jury as a defendant, as somebody who's accused, that, oh, that story wasn't exactly accurate, or I made a mistake, or I forgot a fact on it, there's a presumption in that process that you're telling an untruth to get out of trouble. And that is really the primary reason why you don't give a statement, because you don't know all the moving parts of a case. You don't know what's being investigated. You don't know all the allegations. And then before you decide to chip your story into stone, you want to know everything about the case, and or everything about the state's case or federal case against you. So in the vast majority of cases, when I am retained by clients, I will send out letters, let the police officer know by phone that we're not going to give a statement. However, there are unique circumstances where my client and I can go over the entire case. We know all the moving facts. We know what the accusations are. We know what all the witnesses are, or lack thereof. We know everything that's going on, such that we can make a calculated decision to give a statement. And I stress the word calculated because you can't predict how somebody else is going to take a set of facts. But if you've spoke to somebody who has looked at 1,000 criminal cases or a couple thousand criminal cases and has looked at them from the initial beginning through various proof standards, through conclusion, there is a point where a lawyer becomes a counselor at law because they have had so much experience with legal cases. And that is the type of person you want to talk to, who's bound by attorney-client privilege, when you're weighing whether or not it might be a good idea to give a statement or not. Having said that, I think that gives you an idea why criminal defense lawyers, as a general piece of advice, always say if you're under an investigation, don't talk about it. Just tell the investigating officer, a person that you'd like to talk to a lawyer before you talk to them. And if they arrest you, don't let it rattle your cage. Say the same thing again. I'd like to talk to a lawyer before I talk to you. Because that's a reasonable response under the circumstances. I hope this helps.